Welcome back to the High Court Report, your one-stop shop for Supreme Court coverage. I come to you today to recap oral arguments from this week and deliver major updates on 3 Supreme Court actions that demand your attention. Subscribe and comment via the High Court Report YouTube page. Navigate there to listen to oral argument clips and engage in discussion. I try to upload YouTube shorts a few days a week. Also, subscribe to the High Court Report podcast and follow the High Court Report on LinkedIn. On LinkedIn, I provide rundowns of Supreme Court cases and post informative graphics. Finally, please rate and share the High Court Report with friends, family, coworkers, neighbors, or anyone who wants to follow the Supreme Court. Our goal, make Supreme Court coverage accessible to all. Here's today's plan. First, I'll update you on 3 Supreme Court actions, 2 unanimous decisions, and 1 explosive voting case. Then, I'll break down this week's oral arguments. Finally, we'll preview next week's Blockbuster cases that promise to reshape federal power. I'm testing out analogies for some of the cases to help simplify them. Let me know what you think. All right, let's begin with recent Supreme Court events. On November 24th, the court delivered 2 per curiam decisions with no dissents, meaning all justices signed these decisions. Clark versus Sweeney and Pitt versus Mississippi. In Clark, a Maryland jury convicted Sweeney of second-degree murder. During jury deliberations, one juror broke the rules and visited the crime scene on their own. The judge kicked that juror off and continued with the remaining 11 jurors. Sweeney appealed his conviction. He argued his lawyer messed up by not asking the judge to question all the remaining jurors to see if the rule-breaking juror had influenced them. Here's where things went off the rails. The appeals court gave Sweeney a new trial, but not for the reason he asked for. Instead, they cited a completely different legal issue that Sweeney never even mentioned in his appeal. The Supreme Court said, "Hold on, you can't do that," and reversed the decision. The Supreme Court sent the case back with clear instructions. Decide Sweeney's actual complaint about his lawyer, not some random issue you came up with on your own. So Sweeney's conviction still stands for now, but the appeals court has to properly review his real claim. This illustrates the party presentation rule, which, as the court said in this case, to put it plainly, courts call balls and strikes. They don't get a turn at bat. This rule means parties get to decide what arguments to make, and courts decide who wins based on those arguments. Courts generally can't invent new arguments that nobody raised and base their decisions on those instead. So if you're ever in a case where a judge decides an issue that neither party raised, think about the party presentation rule. Next, the court decided Pitts versus Mississippi. This case stood out because the Supreme Court rarely pulls a big brother and overturns state Supreme Courts, but they did it here. Here's what happened. Jeffrey Pitts got charged with sexually abusing his 4-year-old daughter during a weekend visit. When the little girl had to testify at trial, the judge put up a screen between her and her father so she wouldn't have to look at him while talking about what happened. The problem, the judge never explained why the screen was necessary in this specific case. Mississippi has a law that automatically allows screens when children testify, but the Constitution requires judges to make individual decisions, not just follow blanket rules. The Supreme Court said, not so fast. They ruled unanimously that you can't just automatically put up screens without looking at each case individually. The Sixth Amendment gives defendants the right to face their accusers, and you can only take that away if there's a specific reason in that particular case. The Mississippi Supreme Court had said the automatic screen was fine, but the U.S. Supreme Court reversed them. It's notable because the Supreme Court usually lets state courts handle their own business. They don't often step in and say, "You got this wrong." The message: even when protecting children, courts must follow constitutional rules and make case-by-case decisions rather than applying one-size-fits-all solutions. Now, you must have heard about the Blockbuster update that will shake up redistricting nationwide. Abbott versus League of United Latin American Citizens. Here's what happened. A federal court in Texas looked at the state's voting maps and said, these are illegal. The court found Texas drew district lines based on race, which violates the Constitution. They spent 9 days hearing evidence, reviewed thousands of documents, and wrote a 160-page decision explaining why Texas broke the law. Texas appealed to the Supreme Court and asked them to hit the pause button. They said, don't make us redraw our maps right now. Let us use them for the 2026 elections while we appeal. On December 4th, the Supreme Court said, okay, Texas wins for now. The majority found the lower court made serious mistakes in how they analyzed the evidence. Justice Alito wrote a short opinion agreeing with the majority. He said Texas drew these maps for political reasons, not racial ones. Plus, Texas needs to know which maps to use for the 2026 elections. You can't change the rules this close to game time. Justice Kagan fired back with a sharp dissent joined by Sotomayor and Jackson. She blasted the majority for overruling the lower court's findings based on paperwork they reviewed over a holiday weekend. She pointed out that Election Day is still 11 months away, and Texas could even change their primary election date if needed. The bottom line, Texas gets to keep their contested maps for 2026, potentially giving Republicans 5 extra House seats. With razor-thin margins in Congress, those 5 seats could determine which party controls the House. And this decision gives us major clues about Louisiana versus Calais, a case that could gut the Voting Rights Act entirely. Abbott shows the court's growing skepticism toward any redistricting that considers race, even when it's meant to protect minority voting rights.
Okay, let's move on to this week's oral arguments review.
Starting with Cox Communications versus Sony, the billion-dollar battle over copyright infringement and piracy. The justices seemed genuinely troubled by the predicament. As Justice Sotomayor put it, Option 1, Cox says they can't tell which specific person in a house or apartment building downloads illegal movies. So if Cox gets blamed for piracy, they'll have to cut off internet service to entire families, including innocent people. Option 2, Sony says if Cox faces no consequences, they'll never bother removing pirates from their network. Illegal downloading will run wild. The court's main question, what does Cox need to know or do before we can blame them for their customers' piracy? Is it enough that Cox simply knows some customers download illegally, or must Cox actively help the piracy happen? Sony's lawyer, Paul Clement, wanted a low standard. He argued Cox should face liability when they know piracy will substantially certainly happen on their network. But Justice Kagan and others pushed back, noting the court recently rejected this substantially certain approach in social media cases. Fun fact, Paul Clement himself helped convince the justices to reject that approach a couple years ago. I think the justices will side with Cox. The court lately avoids holding companies liable for their users' bad behavior. Plus, the copyright law Sony relies on doesn't explicitly say internet companies can face liability. The justices will probably tell Congress, if you want to blame internet companies for piracy, write a clearer law that actually says so. Next, let's recap Urias-Orellana versus Bondi, the Asylum Authority showdown. Cartel violence collides with court deference. This case involved a question about whether courts must defer to government officials' findings about whether a person suffered past persecution, a necessary finding to secure asylum. Let me put a different spin on it. Imagine your house getting damaged in a storm. Your roof and siding get damaged and water seeps into your attic. You file an insurance claim because your policy says they cover insignificant property damage from storms. The insurance adjuster investigates and finds facts. Your roof lost 15 shingles. You have water stains on 2 walls, and repair costs total $8,000. The question becomes, who decides if those facts add up to significant damage? That's the issue here, except in the immigration asylum context. The government wants courts to defer to the adjuster's conclusion that this constitutes significant damage. The petitioners want courts to make their own independent decision about what counts as significant. The justices seem to agree this involves both factual findings, how many shingles, how much water damage, and legal interpretation, what legally counts as significant. I think the court will say, trust the adjuster's factual findings about the actual damage, but let courts decide whether those facts meet the legal definition of significant damage. Despite repeated mentions in the briefs about Loper Bright Enterprises, the decision that overturned Chevron deference, Loper Bright didn't explicitly surface during oral arguments. We will surely see Loper Bright mentioned in the opinions. Then, the court heard arguments in First Choice Women's Resource Centers versus Platkin. The case centers on whether First Choice possessed Article 3, standing to challenge New Jersey's subpoena, demanding donor names and contact information. The Attorney General issued a sweeping subpoena commanding First Choice to produce donor names, addresses, and phone numbers so his office could contact and question them, all on pain of contempt. It's like a building inspector showing up at your business with a subpoena demanding your customer list so the city can contact customers about safety concerns. The inspector says, hand over those names or we'll hold you in contempt and shut down your business. You argue this violates your customers' privacy rights. The city responds, but we haven't actually shut you down yet. We'd have to go to court first, get a judge's order, then enforce it. So there's no immediate harm. Meanwhile, your customers are already fleeing because they don't want city officials calling them at home. Justice Gorsuch cut straight to the heart of standing doctrine when he noted you don't need litigation costs for Article 3 standing. This reflects the court's broader skepticism about requiring plaintiffs to shoulder expensive litigation before obtaining federal court review. The imminence requirement became the central battleground. New Jersey argued that since they must go to court and obtain a court order before actually shutting down First Choice, requiring multiple procedural steps, no imminent harm exists. It's like the city saying, we haven't actually padlocked your business yet, so you can't sue us. The justices seemed skeptical, pressing both sides on whether these procedural safeguards really defeated standing. First Choice sidestepped the imminent harm requirement entirely by arguing credible threat analysis. Their lawyers said First Choice faces credible enforcement threats because the Attorney General already initiated enforcement proceedings and filed sanctions motions. In our analogy, it's like the building inspector already filing paperwork to start closure proceedings while claiming no immediate threat exists. First Choice also argued their associational interests suffered immediate harm upon receiving the coercive subpoena, regardless of whether enforcement requires additional steps. Just like your customers start fleeing the moment the building inspector shows up demanding their names, donors get scared and stop giving money as soon as they learn the state wants to contact them. Nerd note, I'm interested to see how the court reconciles the pre-enforcement litigation costs question here with the litigation costs in Boston. This was a case the court heard in October about whether a person can challenge Illinois's voting law that lets officials count ballots received after Election Day. To learn more about that case, check out my podcast preview and oral arguments. This past Wednesday, Olivier versus City of Brandon. The court had to answer if you pay a fine, do you forever lose the chance to challenge the law that created the fine? Here's an analogy. It's like saying if you pay a speeding ticket to avoid court hassle, you permanently lose the right to challenge whether the speed limit sign was legally posted. I think the court will rule in Olivier's favor. Justices across the aisle seem perplexed that someone can't challenge the speed limit sign just because they paid a speed limit fine. Using the speed limit analogy, the city rebutted, You should have fought the ticket in traffic court, requested a hearing, or appealed to state court instead of suing us in federal court. But Justice Jackson pressed them to admit all those options keep you stuck in the same local court system that issued the questionable ticket in the first place. This reflects a bigger worry from both the Platkin and Olivier cases. The justices didn't seem enthused about trapping people in state courts when they have federal constitutional rights at stake. That's it for this week's recap. Let's round out today's episode with a quick peek of next week's full slate of cases, where we have 2 Blockbuster cases. Check out my case previews and my mega episode for in-depth breakdowns. Monday, December 8th, Trump versus Slaughter. This case involves Trump's presidential power play over independent agencies. The big question, can the president fire commissioners from independent federal agencies like the FTC without giving a reason? Trump fired FTC Commissioner Rebecca Slaughter, and now the court must decide if that was legal. Currently, these commissioners have job protection. The president can only fire them for cause, meaning they did something wrong. Trump wants to change that rule so he can fire them whenever he wants. This case could reshape how much control presidents have over federal agencies. If Trump wins, future presidents could clean house at agencies like the FTC, SEC, and Federal Reserve whenever they take office. Tuesday, December 9th, NRSC versus FEC. This case involves money, messaging, and political speech. The National Republican Senatorial Committee wants to spend money supporting Republican Senate candidates, but current FEC rules limit how they can coordinate with those campaigns. The NRSC argues these restrictions violate their First Amendment rights to political speech. The FEC says the rules prevent corruption and keep elections fair. The decision will impact how political parties can support their candidates in future elections nationwide. Wednesday, December 10th, doubleheader, Ham versus Smith. Oink. The IQ Showdown. This case asks, can someone be executed when their IQ scores hover right around the cutoff for intellectual disability? Joseph Smith sits on death row, but he claims the state can't execute him because he has an intellectual disability. Problem? He took 5 IQ tests and scored 75, 74, 72, 78, and 74. Doctors usually look for 70 or below. Smith never scored below 70, but lower courts still found him intellectually disabled based on his problems with social skills, independent living, and basic academics. They said you have to look at the whole picture, not just numbers. Alabama wants courts to focus mainly on IQ scores. Smith's lawyers want the comprehensive approach that considers everything. The case could determine whether states can rely heavily on raw test scores or must use broader clinical evaluations. FS Credit versus Saba, Investment Industry Showdown. This case asks whether shareholders can sue investment companies directly or must rely on the SEC to enforce the rules. FS Credit says only the SEC can enforce these laws. Saba Capital says shareholders should be able to sue when the SEC doesn't act. The ruling will impact how investors can protect themselves across the entire investment industry. After this week, the court will be off until January 12th. January brings more monumental cases. We'll be sure to preview and cover these cases. Thanks for listening to the High Court Report. If you enjoyed the content, please follow, rate, and share the podcast. Also, we always welcome fan engagement, so follow our LinkedIn page or shoot us an email if you have any questions or comments. Talk to you soon.